Good afternoon and welcome to the regularly scheduled meeting of the San Francisco Ethics Commission for January of 2018. I'm going to call the roll. We have excused absences on the part of Vice Chair Chu and Commissioner Lee. So, Commissioner Rennie.
Present.
Commissioner Cobb.
Here.
And the chair is present, so we have a quorum, and we'll proceed then with the item number 2, public comment on matters appearing or not appearing on the agenda.
Good afternoon. My name is Ellen. I am a psychiatric social worker for the Department of Public Health for more than 11 years. I am a SEIU shop steward, and I am a bargaining team member for the public services employees. We had approximately 16,000 public services employees. And again, my name is Ellen. That is ELLEN, LEEZHOU. I am here today to ask you to do an investigation on the Ethics Commission Department. I represent public workers. I brought 5 public workers who experienced retaliation, discrimination with the Ethics Commissioners. We reported to them between April to June 2017. I was with them. I was with all 5 of them, make the initial interviews. And we provide with them a lot of reports, documentation to the Ethics Commission staff. 3 months ago, I was informed, one of the employees from the Ethics Commission, that they do not have our record anymore. I follow up with the Ethics Commission. They said there's no record to be found. 5 of us, plus myself, 6 people still alive, still working for City and County of San Francisco. This is not acceptable. Many of the SEIU 1021 members and city employees from different departments, we spoke to the civil services commissioners and testified at room 400. Many occasions, many members, between 2015 to 2017. We talk about bribery, we talk about extortion, we talk about retaliation, and we talk about ongoing investigation from the city attorney and the district attorney, plus the Federal Bureau investigators. Yet, the problems repeated over and over again. The people who stood up and report extortion, it was never addressed. Since I am a sub-store, I provide the services, and I took them and report. The Ethics Commission refused to follow up. The EEO department and the whistleblower and the DHR refused to keep records. I was told from the last time, 2017, the Ethics Commission will get a subpoena to get the records. But now we are told there's no records to be found. This is insane, and this is not democracy. This is called corruption. And I'm here to ask you to do an investigation for the Ethics Commission, who is not ethically. That is not acceptable. And we're still alive. We still have a lot of workers who've been to retaliation, that we stood up for corruption. We stood up and we say no to them, and that was why that we report. And myself, I'm a public services employee. This is not acceptable. I'm asking you to do investigation. For the purpose of record, I'm going to give you a copy of record. Thank you.
Could I ask you a question?
Yes.
You said a number of things, but I'm particularly interested in one thing you said. That you said that you gave the Ethics Commission staff, you and the people you represent, a bunch of records?
Yes.
Let me finish. You gave them the records, and then you were told later on that they never got the records? Or what were you told?
I brought 5 people and myself, 6 people. We did initial interview. We provide them with documentation and evidence of corruption and retaliation.
Did you give records to the Ethics Commission?
Yes.
And then did they tell you that they never had the records?
Nothing. They said they do not have the record.
Okay, fine. All right. Thanks a lot.
This is exactly what corruption means.
Ms. Pelham, do you have any response to that in regard to having been given records and then the records not being available or being told that no such records were given? That's the thing I'm mainly interested in here.
I'd be happy to, if we can go and provide comment in closed session on confidential personnel matter. I think that would be the appropriate place to handle it. I'm happy to provide the commission with whatever information it might need, but I think it would be appropriate in that session rather than in public session.
This is a public entity.
No, please, we've heard from you, ma'am.
Thank you.
So that's I don't have any problem in regard to the substance of whatever these complaints are, but we're being told, and the public is being told, that records were given to the Ethics Commission.
Yes.
You can sit down, ma'am.
Thank you.
I need to talk with Director Pell. Records were given to the Ethics Commission, and then the Ethics Commission has no idea about these records at all. I'm not asking for the substance of anything. We don't have to go into closed session on it, but I think that's kind of significant. Can you explain it?
What I can explain is that we did not receive records. We have no record of receiving records from the complainant.
Okay, fine. That's the response then.
Let me
Commissioner
follow with a question to Ms. Tang.
ELLEN, Ellen, Lee Zhao, ZHOU.
Okay. What day did you deliver such records?
I met with the Ethics Commission staff between April to June 2017,
No,
many occasions.
I didn't ask you for the total meetings. What is the date you handed documents allegedly to anybody on the Ethics Commission staff?
To be fair, I do not have a specific date because I met with them many different days between April to June 2017. But I do have the record. I just did not bring it right now in front of me. I do. We have the documentation, we have the record, we recorded.
Where?
Inside Ethics Commission Department with ethics staff. And 6 of us still alive and still working for the city.
All right. A question to the executive director. What's the custom and practice when you receive written documents?
If I could, Your Honor, or Judge Kopp, the custom and practice is to keep them in a complaint folder.
All right.
Either
Do
as
you record the date received?
we do, yes.
Okay. And do you have any such recordation of the date of receipt of any such records?
There's a bit of a nuance to what we told Ms. Zhu. What we told her was that we do not have record of complaints being lodged by those 6 individuals regarding retaliation. We have documentation that they gave us in the course of a different investigation that is connected to that investigation. But those 6 individuals were interviewed as witnesses and were never recorded as complainants.
Okay. So those documents relate to interviews. Is that accurate?
Yes.
And is there any document which records the date of receipt of any document which could be a complaint?
If we understand it to be a complaint, yes, it is logged as a complaint with a time on it. There's a timestamp placed on it, and it's placed into a folder.
And do we have any such?
Not from the 6 individuals that she mentioned.
Thank you.
Okay. Any further public comment?
Hi, Commissioners. Larry Bush for Friends of Ethics. I wanted to bring up an issue that we've brought up in the past. And that's that state law requires that agencies report publicly the disclosure of gifts that they make available, like tickets to events and so forth. That's a Form 801 and 802. 801 is a gift to the agency. 802 is a gift that the agency makes. And I would like to recommend that those be filed with ethics as well as with individual departments, because it's very difficult to track what's going on. If you go back and look, for example, at the Recreation and Parks Department, They are not reporting any gifts that they've given since August of 2016, which seems unlikely. Other departments like War Memorial do it monthly, as they should. So I would recommend, for the convenience and transparency, that these also be filed at the Ethics Commission. Thank you.
Thank you. Further public comment, sir?
Good afternoon. My name's Douglas Yep, and I've lived in San Francisco for 65 years. For the record, I do have permission to be here, so what I have to say is important. The first thing I have to say is I have to commend the present Ethics Commission for doing such a great job. I'd like to put on the record that whatever you're doing is being closely watched across the country. The reason why it's on the record, so this way later on, some of the bad boys can't say they weren't warned. Due to a recent important death, I was told in a certain way that a judgment was made. And as one person told me, that person received the ultimate penalty. I guess in human language, it's called the death penalty. We're not here to judge that person's character. All I have to say for the record is that he's no longer here, and anyone can make their own conclusions as to whether that's good or bad according to your own point of view. The first speaker, the lady that spoke just now, is very correct. I myself went through the same process way back when, under the previous administration, when I filed written documents regarding the so-called residency of Sean Ellsburn when he ran for re-election. And when it came down to certain departments in the city, including the city attorney's office, all of a sudden there was no paperwork to be found. So of course, nothing was ever resolved because I took the attitude, sooner or later, we'll get to the bottom of it. And like they say in the Al Capone case, if you can't go through the front door, we'll go through the window. Thank you.
Thank you. Any further public comment? If not, we'll then move to agenda item number 3, discussion and possible action on the draft minutes for the Commission's December 18th, 2017 special meeting. Commissioners, anything on the minutes? Commissioner Kopp.
Well, there's just one misspelling. It's on the first page. The word is, should be C-I-T-I-N-G, and it's spelled S-I-T-I-N-G, and if that takes a motion to amend, I will, it's under public comment.
All right, well, that'll,
Last paragraph, second line from the bottom.
without objection, then that'll be
Okay,
corrected.
And then I'll move approval.
Commissioner Rennie.
One other correction in the sentence that follows, or that is part of the correction cited by Commissioner Kopp. In the penultimate sentence, it says within, and within should not have a space between the with and in.
Could we get a little, I missed where Commissioner Kopp's was, so then I couldn't relate to where Commissioner Rennie was saying to make the change.
Well, the
Should be
Commissioner
one
Kopp's
word.
Page 3/6 at the bottom. Or at least when I printed it out, that's what it came out.
How did I miss that?
Okay, page 3.
Under, when you, item 5, public comment, it's citing, it's got
Okay, I got it.
S-I-T, and it should be
Thanks.
C-I-T.
And then there's a within somewhere?
As you go on, it's within, not with space in.
Great, thank you.
Okay, any other comments on the minutes? Or without objection, Commissioner Rennie's change will be made as well.
And I'll second Commissioner Kopp's motion to accept the minutes as amended.
All right, all those in favor of accepting the minutes, please say aye.
Aye.
Opposed? The minutes are unanimously accepted.
Excuse me, Chair, would there be public comment on the minutes?
Oh, yeah, I'm sorry. Yes, please. So, any public comment in regard to the minutes? Thank you, Director Pelham. Okay, hearing none, we'll then go to item number 4, discussion and possible action on amendments to the Whistleblower Protection Ordinance, San Francisco Government Code Section 4.100 et sec. Kyle.
All right. Good afternoon, Commissioners. So I'm going to be giving you just a brief background that I'm sure some of you are all familiar with, but for the purpose of the public and any members watching, I'm going to do a brief background, and then I will leave it to Deputy Director Bloom and myself. If you have any questions, we'll relay those after I'm reseated. So this issue, the Whistleblower Protection Ordinance, has come back up at the urging of commissioners and members of the public because of the sort of long extension of this process. Originally, the Whistleblower Protection Ordinance was reviewed as part of a civil grand jury report of 2014-15, and based on Ethics Commission proposals, a amendment or several amendments to the Whistleblower Protection Ordinance were passed by this commission and given to the Board of Supervisors in 2016. Following that passage, and the sponsor, Board President Breed, asked that we confer with the Controller's Office, DHR, and other interested parties to meet and confer regarding the Whistleblower Protection Ordinance. We've had those ongoing discussions over the past year, and we are now prepared to finalize and have that meet and confer meeting. What your agenda item has in front of you today is a 2017 version that differs from the 2016 version that was submitted to the Board of Supervisors in 2016. So I will run through that a bit here, but we are urging that you all today vote to go forward in approving the 2017 version of this ordinance as amended by staff. Briefly going into the 2016 version, you will see on agenda item 4, page 2, there's a list of 7 items that were amendments proposed both in the civil grand jury report and by discussions in front of this commission. All of the items listed in the list you have in front of you did get into the 2017 version of the whistleblower ordinance, but for the number 7, which is an expanded whistleblower retaliation protection to include covered complaints filed not only with the city and county, but also with any state or federal agency. After engaging the Controller's Office, the Department of Human Resources, and interesting bargaining units, the 2017 version, we believe, reflects the sort of best opportunity to go forward with the Whistleblower Protection Ordinance. And you will note that the 2017 version actually adds a number of provisions and clarifications, in particular with regards to supervisorial duties when a whistleblower complaint is given to a supervisorial staff. The one instance where the law is perhaps revised or narrowed from the 2016 version is the portion of the law in which the local agencies would be involved in a complaint that is made to a state or federal agency. Both the Controller's Office and the Department of Human Resources thought that because of a number of issues that it would be almost impossible to track complaints, whistleblower complaints that are submitted to the state and to those state or federal agencies or offices. The difficulty comes with a lack of sharing of certain confidential information and a number of other provisions that we simply, in working with them, just did not believe that we could include in this item. However, going to the 2017 version, there is a number of expansions within the 2017 version and clarifications that we believe more than rectify that revision, including, as I said, requiring supervisors to obtain training that we have all taken regarding whistleblower complaints and the proper method and procedure to identify those complaints and what they need to do when they receive those complaints and how to do that in a timely fashion. It delegates responsibilities amongst the parties who have oversight over this, over the whistleblower thing, or it clarifies the duties between the controller's office and our office for complaints. It requires that any city officer or employee who retaliates against a city contractor for engaging in protected activities be disciplined. So it clarifies not only the procedure, but also the discipline involved. So I think with that, I'm sure there's a number of questions, and I know the public is very interested in this item. I think I will open it up to you all for questions or clarifications regarding the changes between the 2016 version that you all passed and the 2017 version we are asking you to approve and go forward with as it relates to this item.
Commissioners, Commissioner Rennie.
What is the reason that whistleblowers are not deemed to be protected if they're retaliated against when they blow the whistle through, say, a newspaper? Why is it necessary to go to the supervisor rather than dealing with the retaliation because they've disclosed something to a newspaper or to a state agency?
So as a general policy matter across governments, local, state, and federal, whistleblowing to the press is not something encouraged by whistleblower protection laws. People are free to exercise their First Amendment rights and whistleblow to the press, and then they are entitled to damages through the court system under the First Amendment if they succeed on the merits in federal court. But as a general policy matter in the city, state, and federal levels, the government, through whistleblower protection laws, is trying to incentivize people to whistleblow internally so the city can swiftly deal with the corruption or misuse of city resources.
Commissioners, any, I have a couple of questions, and maybe my memory is faulty on this, as it is on many other things, but I had thought that last time when we talked about this Whistleblower Protection Act, that we had talked about it, about the fact that this commission did it quite a while ago, and it's not moving at all through the Board of Supervisors, and it seems to be dead in the water. From their perspective, where they're just stalling it, and that we came to a conclusion last time that we would therefore go ahead and put this on the ballot. And we talked about that, and there was even some discussion about whether or not we needed, if there was something that needed meet and confer status, would that in some way prevent this from being on the ballot? So I sort of have been looking forward to today to discuss putting this on the ballot. We couldn't do it anyway because we don't have 4 votes. You know, we couldn't do it as a supermajority. But what happened to the idea of putting it on the ballot? Did that just sort of go up into the ether, or?
Yeah, go ahead.
Recap that. Yeah, so Chair Keene, this is addressed towards the end of staff's memo, so the bottom of page 3, starting to the top of page 4. I think they make 2 salient points, and they make them accurately. The first is that meet and confer is required before any city agency, whether it's the Ethics Commission or the Board of Supervisors, puts this on the ballot. So that meet and confer process must still be completed, even if this were to proceed as a ballot measure, and that must come first. Secondly, and this is also discussed in the staff's memo, some provisions of this proposal could fall outside of the Ethics Commission's jurisdiction to place it on the ballot as a proposed measure. The Ethics Commission's jurisdiction is limited, as you know, to ordinances relating to governmental ethics, campaign finance, conflict of interest law, and whereas certainly much of this will concern governmental ethics issues, some of it may fall outside the scope of that jurisdiction. So we would also need to carefully analyze it as well.
Thank you. Ms. Pelham, you and I had a very brief conversation about the whole idea of if there was a bar to putting it on the ballot because of meet and confer requirements regarding some of the materials, that some of the matters in here, that those matters could be separated out and we could put the bulk of it, which is the rest of it that doesn't confer, doesn't have anything to do with meet and confer, we could put that on the ballot. Is that something that we've given up on, or?
I don't think we've given up on that at all. I think, to the city attorney's point, the first question would be, the first question would be, which version are you interested in putting on the ballot?
Okay.
I mean, we feel that the agendizing the item today is to get clarification and from you all about if this is a version that you want to authorize us to move forward with through the meet and confer process. On that note, just as a point of information, we do have a second meet and confer scheduled for January 24th next week. So I don't know how long that process will take, but this is the second of meetings we've had that we will have had to discuss these issues. We want to make sure we're using the version of the ordinance the Commission is comfortable with. And then once we know that, if the Commission acts to adopt this, we would proceed with that conversation. We would also proceed with understanding from the City Attorney, are there things that need to be bifurcated? And then we could bring them back to the February Commission meeting for the Commission's action at that time. To place something on the ballot for June 2018 would require the Commission to provide that ordinance to the Elections Department by the end of February. The Commission's next meeting is next regular meeting is scheduled for February 16th. So there are some moving targets here, but there could be some time for the Commission to do that in time for a June 2018 meeting, depending on how the conversation with the meet and confer goes. And yes, and I'll turn it over to
Ms. Bloom.
I wanted to add that the part that is subject to meet and confer in the Whistleblower Protection Ordinance applies to the requirement that supervisors in the city receive complaints or alleging retaliation and report them to the Ethics Commission and can be fined for that, which is really the bulk of the significant revision to the Whistleblower Protection Ordinance, because that expands the category of protected activity from the departments where you have to file these complaints from like 4 to 8,000. So if we removed that portion from the Whistleblower Protection Ordinance in order to push it through to the ballot and not go through meet and confer, we would substantially water down and weaken what we've attempted to do here. So we view that as really not an option. We want to go through the meet and confer process, satisfy our obligations, and get the version that we have today, the 2017 version, through, whether through ballot or through the Board of Supervisors.
Okay, well, that makes sense then. If by separating out the parts that require meet and confer, we're just left with nothing, or nothing that has any teeth, that's certainly not worth doing. It's just that we've now come on to 2 years since this was under Commissioner Rennie's watch when he was chair, and we're still futzing around with it, and we're now about to go into more meet and confer, which seems to be something that takes forever. And it would seem like it's going to preclude us from getting it on the ballot, at least for June, maybe for this whole year. Am I wrong on that?
Well, I have an update on that regard. I spoke with the Department of Human Resources staff who is working on our meet and confer process for us, and she seemed very optimistic that the January 24th meeting would satisfy the concerns the unions raised in the very first meeting, and that perhaps it would conclude after that second meeting. She thought that maybe there would be a third, but she was pretty optimistic that this second meeting would be would conclude the meet and confer process. If that's the case, then we would be able to move forward in February with Council Shen's recommendation to remove the portions of this version that apply only to the controller and have nothing to do with governmental ethics, and we could then put that on the ballot.
Good. Well, why don't we keep that in mind as a priority here, rather than to just go back into the weeds for more meat and conferring, that to get this thing in shape to go on the ballot, and stay optimistic in regard to what you've been told, that it'll be done at the end of January and we can get it on, rather than having it drop down the rabbit hole for another couple of years and forever. So let's see what happens. But hopefully, if everything works out with the meet and confer, and if we could have this at our next meeting then, which would be our last chance really, to have a vote, get 4 votes and put it on the ballot for June, I think that's something we really should try our best at doing. That's my opinion. Commissioner Rennie?
Well, as I understand what staff is asking us first, because we had originally had a 2016 version, which is the one we sent to the board. After their meetings, they've made some revisions, and they've now proposing the 2017 version, which they want us to either say, yes, that's the one to go forward with, or no, we want to go with 2016.
No, I understand
So that the first vote is but I've got some questions about.
I understand that, but my point is, whichever one we decide on, whether it's the 2016 or the 2017 one, let's move it forward with dispatch to get it on the ballot. That was the point, the only point I was making.
Absolutely. But I have a couple of questions about the meet and confer. Suppose you meet and confer, and the agency says, we don't like this, or we want that, and we don't agree to what they say. Can we ignore them?
So it depends on a lot of factors. Obviously, at the next meeting, we'll see what the interested unions have concerns about, if anything. Maybe they just need an update. Maybe there won't be any further dispute. But a meet and confer doesn't require complete agreement on all points. And exactly what would be required to satisfy a meet and confer obligation, short of obviously full agreement, depends on, at least it's my understanding, depends on the categories of employees affected, as well as the MOUs that govern those categories of employees. So it's a little bit of a moving target because of all those variables, exactly what we need to proceed with. And obviously it depends on the nature of their objections or concerns, if any. So it's hard for me to provide a complete answer at this point. It's a little bit early in the process to say.
Well, but is there, legally, is there any way that they can block us if they don't agree?
I mean, I think it's more of a procedural requirement as opposed to a substantive requirement. If we go through and complete all of the legally required procedures, then we satisfy and meet and confer. Now, if we ignore those procedures or don't comply with those procedures, then I believe there's other actions that they could take to enjoin us from doing it.
Right.
But it's more about, you know, crossing all the T's, dotting all the I's, taking care of all the steps we need to take. Again, it's not my understanding that meet and confer requires complete agreement by all interested parties on the proposal.
My understanding has always been that agreement is really irrelevant. As long as you've met, you've conferred, and you've covered all of the items that you have to meet and confer on, that's what's required. And both sides can be in complete agreement. You move on then to the next step. The meet and confer process now is over. It's been met with.
Right. It's more of a procedural matter, just going through the process.
Well, if I may, Mr. Chairman, be recognized. You articulated the point I wanted to ask a question about. Meet and confer. You meet and confer once. There's no veto power over the action of this commission. I mean, how many times do we have to meet and confer, Mr. Shen?
Again, I'm not sure I can provide you with an answer today. I mean, there's a lot of variables.
Well,
Again, which unions are involved,
I'd like an answer.
what concerns they have, what objections they have.
Okay, can you give us a written answer by our next meeting?
I can certainly provide you with further guidance. That guidance may not just simply be a number in terms of the number of meetings that need to
All right,
occur.
and who are we meeting and conferring with? Name the unions.
The first meeting involved several different unions. The ones who expressed interest were 1021 and MEA in a second meet and confer meeting. And so they will be present on January 24th. And then the Department of Human Resources staffer advised that a couple of other additional unions who weren't there the first meeting were interested in coming to the second meeting as well. I will say that I put to her the question of how many meet and confer meetings are required, and she said that generally a rule of thumb is 2 to 3. And
Well, that's just a rule of thumb.
there's no,
But we're up against a time deadline.
right. There's nothing in the
And,
memorandum of understanding that require a set number of meet and confer.
Yeah, I want to vote on February 16th to submit this to the voters in June. I mean, this is like a free-for-all.
I agree. I think
Yeah, there's
Commissioner
two
Cobb's
unions
point.
at first, and then two more are going to jump on and say, well, we only got one meet and confer, you got two, or you got three, so we want
I
two.
think whoever it is we have to meet and confer with, please meet and confer with them before the next meeting, get that over with, get that out of the way, so we can move forward. And if they say, well, we want more meetings to meet and confer, our position is we've met and conferred. It's,
I will say, if I may,
Yeah.
that I, for what it's worth, I have found the meetings to be constructive. In the first meet and confer, the unions pointed out some language that perhaps didn't mean to them, as the people implementing the law, what we thought it meant. And we were able to make constructive changes to the language in order to address their concerns that I think strengthened the law. So to the extent that these meetings are required, I think that they have been constructive. So I just wanted to point that out.
well, I think you're quite correct. Oftentimes, meet and confer comes through with some valuable results for all sides. But our problem is we're now up against a deadline of something that we'd like to move forward that's been just sort of floating for the last couple of years, and we want to fish or cut bait on it. And so, yeah, meet and confer can provide some valuable stuff, but we got more important priorities in terms of putting this thing on the ballot, and we want to put it on the ballot by June. And in order to do that, we have to vote on it next time. So can we have that understanding and that emphasis being made to the unions as well? We're meeting, we're conferring. After that, God bless you, goodbye, and it's over.
Yeah, no, I think we're very clear on the commission's message, so we will
Okay.
work towards that.
Second question is to Mr. Shin. How long will it take to ascertain any portion of the drafted ordinance which is outside the jurisdiction of the San Francisco Ethics Commission?
I don't think that will take too long. It's not a terribly long ordinance, and I think in terms of that part of the review, I think we could certainly accomplish that by the next meeting.
By when?
Certainly in time for the next meeting.
Well, logically, you should have it before so that staff can then revise the draft. We don't have to try to work through it. I request, through the chair, that opinion be rendered a week before, by February 19th.
Well, and by working through the proposed ordinance, I actually meant to include, I should have been more clear, should have meant that I was going to, of course, include ethics staff in that discussion and review. So as with all projects, I work very closely with the staff and to get their views as well.
Okay. So we have then to make the decision as to whether or not we want to adopt the staff's recommendation that we go with the 2017 version as opposed to the 2016 version. Do we have a motion to that effect?
So move.
I will second it, but I have a couple questions.
Sure, Commissioner
That Friends of Ethics has pointed out some things that they would like changed in the 2017 version. One is the change from substantial motivating factor to contributing factor. What's staff's response to that?
Staff has not researched that as a policy option because in 2016, the commission considered that in context with that version of the WPO, the original version that you passed, and declined. So we did not view that as something that the commission was supportive of pursuing.
Well, what, the requirement that the whistleblower, or, the whistleblower who's been retaliated against, they do have the burden of proof, but under this version, 2017, and under 2016, I guess, as well, they had to prove that it was a substantial motivating factor as opposed to a contributing factor.
So the way the commission dealt with that question in 2016 was to clarify in the Whistleblower Protection Ordinance that that standard of proof does not apply to the preliminary review stage of complaints, and that if a complaint meets all the other criteria for protection from retaliation, that the investigation, that the staff would stand in the shoes of the complainant, and the investigation would circle around whether or not retaliation was a substantial motivating factor in the complaint. And the 2017 version of the WPO retains that language. And as a practical matter, staff has already implemented that change. And as a result, we've been able to open up quite a few more investigations into whistleblower retaliation than we had in the past. So essentially what that means is when somebody can prove that they engaged in protected activity, that their department knew about the whistleblower complaint, and that some suffered from some adverse employment action, we will investigate to determine whether that adverse employment action was a result of the whistleblower complaint.
So that the contributing factor is at the initiation stage. It doesn't require, they don't have to prove it was a substantial motivating at that point.
Exactly, and as a practical matter, they never have to prove anything. The staff investigators stand in the shoes of the complainant when prosecuting the cases before this commission, and the complainant has no role, the whistleblower complainant, in actually prosecuting the case. So the entity that has to prove substantial motivating factor is us. So we are entitled to subpoena the records that they say they can't get. And so we will see them. We will get those records. We can send preservation letters. We can send subpoenas. We can interview witnesses. So to the extent that the complainant himself is not entitled to see the records is somewhat irrelevant if they can establish that they were demoted, fired, or suffered a bad performance appraisal after they filed a whistleblower complaint.
So that the substantial motivating factor only comes into play when the commission or the staff at the commission administrative level
Exactly.
requires it by preponderance of the evidence.
Exactly.
And I think that may be consistent with case law.
Yes, that is correct.
The other question that they brought up was whether or not there should be whistleblower protection against retaliation by a city-funded agency. In other words, that if maybe they don't lose their job, but they get kicked out of public housing. And the reason they get kicked out of public housing was because people were upset, but the fact that they were whistleblowers. Are they covered under that, under our present version?
I do not think so. Whistleblowers can only be city employees or city contractors. We could maybe make an argument that a lessor to public housing is a contractor. We'd have to examine the facts of the specific case.
What's the individual who got retaliated against was a city employee who lives in public housing.
Oh, I see. So the retaliatory behavior is kicking someone out of their house?
Yeah.
No, that would not be covered even under the 2017 version. We would only cover it only covers adverse employment action.
Commissioner Kopp.
Is there any case law on these two standards, contributing factor, and what's the other one, substantial motivating factor?
There's a lot of case law on what constitutes retaliation. I'm sorry, what?
No, I'm surprised.
Oh.
All right, so we're not going into the unknown.
Exactly, right.
And your conclusion and recommendation as a practical matter is that substantial motivating factor is justifiable.
We have not put together an official position on that issue because the commission adopted the language as is in 2016, and it didn't affect any of the stakeholders that we were working with, the Department of Human Resources or Controller or labor unions. So we have no, we've just left it the same as it was in 2016.
Well, I apprehend I'll hear from Mr. Bush on contributing factor. And I've never read any cases which involve either phrase. So maybe you'll be asked to prepare a brief for us, Ms. Blum.
Sure.
Thank you, Mr. Chairman.
Yes, thank you. So we have a motion, and it's been seconded to approve the 2017 version. Do we have public comment on this?
Public comment.
Good afternoon, Commissioners. I'm Dr. Derek Kerr, a whistleblower. No whistleblower retaliation claim has ever been substantiated by the Ethics Commission. Perhaps the burden of proof placed on whistleblowers is too high. In order to show retaliation by a preponderance of the evidence, whistleblowers need access to the evidence. And to show that our whistleblowing was a substantial motivating factor for getting fired, we need access to the evidence. The trouble is that that evidence is in the possession of the retaliator, not the whistleblower. What happens with retaliation is that the retaliation is plotted, is arranged by a group of people who communicate by email in meetings on how to go about excreting somebody from the organization. The only way to get that information is by discovery process and by subpoenas and depositions. I know this because my claim was rejected by the Ethics Commission, but when we went to court and had all the emails and deposed all these people, it all came out. Ethics investigations of whistleblower retaliation do not include subpoenas and depositions. So what you're doing is imposing a legal standard of proof, but without the mechanism for accessing the evidence that you need. That's why ethics has been a dead end for whistleblower retaliation claims. OSHA faced this problem also, and what they've done is to lower their burdens of proof. Instead of requiring a preponderance of the evidence, they accept evidence that provides a reasonable cause to believe that retaliation occurred. And instead of having to show that retaliation was a substantial motivating factor, whistleblowers can just show that it was a contributing factor. That way, OSHA can increase their substantiation rate from 3% to higher than 5%. So if you keep the current evidentiary standard, nothing will change, is my prediction. And I do appreciate all the work and effort that's gone into improving the ordinance. Thank you.
Thank you.
May I ask a
Yes,
question?
Commissioner Kopp.
Doctor?
Commissioner Kopp would like to inquire.
You use the phrase reasonable cause. Is that the same in your presentation as contributing factor?
Reasonable cause is a counterweight to a preponderance. To
Well, you want contributing factor as the standard
Contributing
proof,
factor-
but you also use reasonable cause, and
Yeah.
I want to understand whether that means the same as contributing factor.
Okay, so you have substantial motivating factor versus contributing factor, and then you have preponderance of the evidence versus providing evidence that gives a reasonable judge reasonable cause to believe that retaliation occurs. So that's where OSHA is going. They're sort of lessening the burden of proof.
Well, I know it's lessening, but I don't. All right, thank you.
Doctor, didn't the OSHA handbook is a handbook for investigators, not for administrative judges. And as I understood what Ms. Blum said, is that we essentially are doing what OSHA said. And that is that if there is, when they look at what the complaint, what the whistleblower claims retaliation, what he or she presents to the staff, if there is probable cause that there's merit, it then becomes a matter for the Ethics Commission to hear as an administrative judge, and the staff has the burden, which you say you had to do when you got to civil court, but that the staff does have the power to subpoena records.
But they haven't done so, and that's why your record is 0 over
We understand
23
that.
years.
I understand that, but
Yeah.
what we're hopeful is.
Okay, then
is
that's
with
good.
this ordinance,
Yeah.
assuming that it's accepted by the voters, that we will be able to do essentially what OSHA in its investigators guidebook was,
Yeah.
that all the investigator had to satisfy himself that there was probable cause, and it then would go to an administrative law judge. And that's exactly what, as I understand, based on what Plum said, this ordinance would do. Thank you.
Good.
Commissioners, Larry Bush for Friends of Ethics. A couple of points. I was not aware until just now that the whistleblower ordinance only applied to employment issues and not to other actions that the city can take that are retaliatory. And I'm well aware of the fact that when we've had complaints of mismanagement at assisted housing developments where the waiting list was rigged and bribes were paid, that people who filed those complaints then were expelled from the housing. And your ordinance, as you've got it drafted, would not cover those kinds of situations. So if it's not going to be covered here, it needs to be covered somewhere so that those kinds of things don't happen. I would point out that some of these complaints are filed with the FBI and with departmental inspector general's offices. And I think that people should be protected against retaliation if they file a complaint in those places. I understand the argument that the city wants to channel complaints through city agencies, but that's for bureaucratic convenience. That's not to benefit the person who's facing a retaliation. And I think that you need to put the focus on who it is that's at risk. A bureaucrat is not at risk. The person who loses their housing or loses their job or the conditions of their employment is at risk. And we just had a case in the newspapers of a police officer who won a $100,000 judgment, according to the Examiner 2 days ago, for retaliation after she took the story to the newspapers. That was a case that did not go through city channels. It went directly to court because she did blow the whistle to the press that there was an official in the city police union who was embezzling funds and that the city did nothing about it. She was right to take the case forward, but why should it always fall to hiring an attorney and going through all of that when we have a provision that protects people against retaliation, except in those cases where the complaint is not lodged with a city agency? So what we are requesting is that when you look at this in February, that you ask for a version that includes protection against retaliation of complaints that are taken to another agency, federal or state, or which go to the press, and where there is then a case of retaliation that is lodged and comes to ethics, which handles other retaliation cases. And we also think those should not be limited to employment. You've had repeated testimony from witnesses who came about losing their housing in the homeless programs because they complained about the conditions. And we all know what some of those conditions have been in some of the SROs. People shouldn't lose housing because they brought that to the attention of officials. Thank you.
Thank you.
Can I ask the city attorney if we adopted the suggestion of Mr. Bush that we expand it to state agencies or any U.S. government agencies and the press, is that something that is sort of outside our jurisdiction because it's not really dealing with a claim, so somebody's claiming I got kicked out of housing. That may not be within the ethics department jurisdiction. I don't know, but would you, when you address that question of things being outside, if we were to adopt the amendment suggested by Mr. Bush, would it be a provision that is beyond the jurisdiction of the Ethics Commission?
I'm not sure if I could answer that question now. I think I need a little more time to think about it and also get the Ethics
saying
Commission
the
staff's views on as well.
Right.
But I would observe that it would be a fairly significant change to this ordinance.
Fairly what?
Significant change to the ordinance. I think as Ms. Bloom has already referred to it, in terms of retaliation, it refers to adverse employment action. So if we start bringing other types of action that would constitute retaliation, that would be a pretty big shift in the ordinance's focus. But we can take a closer look at it.
But if it was an employment action, suppose some employee went to the press and he or she gets fired for going to the press and making the complaint, that's retaliation possibly.
Right, and so I think...
it wouldn't be covered under our ordinance as I understand it.
Correct.
And all I'm saying is that if we expanded it to protect, even if you say eviction from an abode may not be an employment action, and that this whistleblower thing is focused on employment action, I'm just curious as to why, if the policy is by some of the city agencies that, well, we don't want to encourage people to go to the FBI. We don't want to encourage them to go to the Inspector General or somebody else. We want them to come to the supervisor, and the employee is frightful of doing that because the supervisor is the one who can kick them off the job. So they say, I'll go to the FBI, and then, so I'm sympathetic to the idea that whistleblowers should be protected regardless of who they went to, if in fact they uncover or they disclose some wrongdoing by the city and they lose their job as a result.
I think this may be more of a policy issue, so I'll defer to Deputy Director Bloom.
Yep.
So if you whistleblow to any state agency or any federal agency about state or federal matters, so state money, federal housing discrimination rules, state housing discrimination rules, you are protected by state and federal whistleblower statutes. So it's not that the city is denying those people a right by excluding them from the city law. And regarding First Amendment whistleblowing activity, those people who are fired for engaging in First Amendment protected conduct can file federal actions in federal courts and obtain damages that far surpass anything that this commission could impose of a single violation of $5,000 for a retaliation activity. I think if you talk to Dr. Kerr, you would find that the damages he won in his lawsuit far exceeded the $5,000 we would have zinged his employer with if we had jurisdiction. And we did not have jurisdiction in his case because it was whistleblowing to the press. So to me, not including First Amendment protection in a retaliation context like this is not a negative. I don't see how our law would be additive in that scenario. If someone is legitimately whistleblowing to the press and engaging in First Amendment activity, their claim in federal court is much better than anything we could do to protect them.
Can you, may I?
Yes, Commissioner Cobb.
Can you distinguish the situation from other complaints to us under which within 10 days, city attorney, district attorney have the right to say, I want to investigate this, and we give them 90 days. If there's no action, then we reassert our authority. Here you'd have somebody filing a complaint with whatever state department it is, FPPC. Does FPPC handle retaliation? No, I don't know which one. Filing a complaint with the federal government. Could we have a system where we would wait 90 days or 110 days, see if anything happens there, and then we pursue it? Because one of the things which concerns me is a duplication of effort by governmental agencies.
I think that's right. I think there would be the potential for duplication of effort, but even more importantly, there's no requirement in any law that the entity that's filing the complaint with the state tell us. So we wouldn't know whether or not they were conducting an investigation into our city. And I think that's the concern that people have, the government has, with encouraging people to whistleblow internally so that the government agency itself can conduct the investigation. But if somebody filed a complaint with the state alleging misuse of state funds in city operations, that person, one, would be covered by state whistleblower protection laws, and two, we wouldn't know about it. And so we wouldn't, and that state agency would be bound by their own confidential investigation requirements, and they wouldn't be able to share information with us about it. So it really is a black hole of information, and that the Department of Human Resources and the Controller's Office were right to point that out to us, and we were receptive to that argument, and we felt that it was important enough to strike that from the law.
Thank you.
Well, you would know about it because the employee who got retaliated against would presumably made some claim.
Not necessarily to us. I mean, they could make it. They should rightfully make it to the state, but I mean, presumably they could make it. They could make the claim to us, but how would we? Like, what would we investigate if the state was already investigating the conduct? You see, it just doesn't seem additive to us.
Okay, I understand.
My thought is, Commissioner Rennie, unless the employee tells our staff wouldn't know.
Right.
Okay.
Mr. Bush has a point to make on this.
In most federal agencies that provide money to the local government, there is an agreement that the federal agency will inform the local government. When I worked at HUD, we certainly had that when we had complaints that came in about housing violations and corruption, bribes, people jumping the waiting list and all the rest of it. We then provided that information to the city attorney's office, as well as to the mayor's office of housing or the housing authority. And it's required as a condition of the city receiving money from the federal government. So I would suggest that you ask DHR and the controller's office to provide you copies of any laws that says that it's not going to be provided, because I don't think it exists. I think that's a convenient explanation for not doing something. Secondly, I think that if you take an action right to court, it means that you have deep pockets of your own to hire an attorney or else find an attorney who will take on the case on contingency. When I had to file on a discrimination case as a federal employee, it cost me about $50,000 before we had any kind of resolution. There are not that many employees who have enough access to cash to do that. I was fortunate. But if I hadn't had that, I would have just been out of luck. The third thing is, even if the federal government or a state agency finds retaliation, they can't do anything to the city employee who retaliated. But if you did something here, you could direct to the agency head that the person who did those wrongful actions pay a penalty of some kind. And you can't do that otherwise. So there are good reasons to proceed with this in a broader scope, in my view. Thank you.
Can I make a clarification?
Sure.
There seems to be a little bit of confusion about whether or not we should or can take complaints alleging retaliation based on discrimination against employees because they're in a protected class or because they are based on sexual harassment complaints. And I just want to make clear that the Ethics Commission does not have jurisdiction over those complaints in any case and would not be able to obtain jurisdiction over those complaints. The Equal Employment Opportunity Office within the Department of Human Resources is the agency delegated under the federal civil rights and state civil rights laws and is the repository and sole investigator of those complaints, with some exceptions when the city attorney's office is involved. So everything has to be reported to them. All investigations are run through them, and we would not be able to get jurisdiction over those complaints, nor do we have it now. And I just wanted to make that abundantly clear.
Sure.
Thomas Bussey. I wanted to pick apart a very precise definition of misuse of city funds in the 2017 proposed ordinance. It says, shall mean any use of city funds for purposes outside those directed by the city. The 2016 version says, misuse of city funds shall mean any use of city funds for purposes outside those directed by the city, and then it strikes out or local, state, and federal law. And this is consistent among every single version, that the misuse of funds provision is very specifically defined, and what does it mean in the negative? And I'd like to compare that against some recent scandals. The city of Beaumont formed a joint exercise of powers authority with a redevelopment agency, which then promulgated a community facilities district, which in 1993 floated bonds, $300 million that was sitting in a bank account that went to the city of Beaumont's finance manager and 3 members of their city council. Not once in a quarter of a century did that agency ever report any release financial reports. It was a massive scandal, and under this proposed ordinance, whistleblowing on that would not be protected because it's not city funds. It's community facilities district under a joint exercise of powers agreement. And we could continue with, say, the 2005 community college district scandal, whereby the real misuse of funds was coming out of an agency in the form of the City College Foundation. Who was writing the checks? City civil service employees who are also the same civil service system as the community college district. So we have defined this very precisely so that it protects the controller who acts as an agent for a great number, a really surprising number of special districts, finance corporations. Does this cover the San Francisco Finance Corporation? Is that part of the city? What about the County Office of Education? I have a suspicion, and I think it is reasonable, that the city unshifts a substantial part of the ERAF. And the reason why they can do that is under this definition. Misuse of city funds shall mean any use of city funds, which the city believes is theirs, for purposes outside those directed by the city. So if the state directs that the ERAF go to the school district, that's not protected under this ordinance. So it's a very, very specific text, and I don't know where it comes from, that protects the controller and the city attorney. Thank you.
Out of the mouth of babes, it seems. I'm Charlie Marsteller for the record, and I was going to speak on the same point. We have what I've always called the city-county dodge. And this is when there's an issue with a city-county agency, in the old days, redevelopment, for example. If a commissioner was appointed and this commissioner had been kicked out of public office for corruption in a city commission, the city-county dodge would, city-county state dodge, the city-county state dodge, they would be allowed to serve on a city, state, or local state commission like redevelopment. And this came up with Mr. Hom, you may recall, the late, great Mr. Hom, who did many things in his career, and some of them were fairly nefarious, and he ended up getting caught up in the city-county dodge to his favor. And these were basically attorney opinions, city attorney, state attorney general, whatever, where this law became null and void when it came to a city and county commission. This gentleman who just spoke really did a pretty good inventory that gives us the magnitude of the problem with these dual agencies under creations under state law, but basically operated by the city. So I did want to say the purpose of the whistleblower ordinance, according to Mr. Bush, is to support and help protect the whistleblower and not the city attorney or the city agencies or departments or anyone else. It's for the whistleblower. That's our focus here. And I did want to say that you've done a lot of work already on this bill, maybe not you directly, but your staff sat in on those meetings. So you have done substantial meet and confer on this in the draft of 2017, and that the 2017 draft is your agent. And the issue is meet and confer in support of the agent, which is in fact the legislation or the proposal that's going to go to the voters. So you should add those meetings that you've already had or participated in because they're on the list. You've already met now, or upcoming on the 24th, at least twice with some of these unions. So be sure to include those in your tally.
Good point, thank you.
It might help people to look at agenda item 4, page 20 of the proposed attachment to 2017 version of the ordinance. Under definitions, 4.110 sub A, city or city agency, whenever it's referred to in the ordinance, shall mean the city and county of San Francisco, its departments, commissions, task forces, committees, and boards. So there's no risk that county agencies will not be included in this proposal.
Thank you, Ms. Bloom. Yes, sir, Mr. Yip.
Good afternoon. My name is Douglas Yap. I was put into a very precarious position in 2007 by my employer, the Department of Public Health, San Francisco General Hospital. To make a long story short, it was very complicated, and in my opinion, there were many obstructionists within the city system who benefited from slowing down the whistleblower system. A certain person was credited with starting the whistleblower system as an investigator. In my opinion, by the time he became senior official, he had switched sides, basically saying one thing and doing the exact opposite behind the scenes. In my opinion, certain city agencies, one of them sitting right here, have a vested interest to slow down the process by their so-called interpretation of what the rules really mean. From my experience going through the whistleblower system, going through the court system, and finally settling with the city, for the record, I feel that there is a lot more built-in obstruction and so-called interpretation that the public is very unaware of. People like Oliver Luby, Derek Kerr, and Joe Lynn basically figured it out. Unfortunately, the public is unaware of the obstructionists. So I would like to caution everybody, for the record, that certain city units have a vested interest to slow the process down and basically say in one word, I will not run for mayor, but then exactly do the opposite. I am the choice of everyone. And we saw what happened to the city when people say one thing and do the exact opposite.
Thank you. Any further public comment? All right, well, we have on the floor a motion to adopt the 2017 version, and it's been seconded. Is there any further comment or amendment? All right. All those in favor of adopting it, please say aye.
Aye.
Those opposed? The measure passes 3-0. Okay. We now go to item number 5, discussion and possible action.
I'm sorry.
Commissioner Kopp.
Yeah, I had spoken with the executive director and deputy exec director about a word on page 38. And the deputy executive director suggested language to correct it, and I'm sorry.
That's all right.
Chairman.
That's fine.
On the top of the page where it just defines unlawful, it's under definitions, defining unlawful activity, violations of any federal, et cetera. I wanted to insert the word written and a preferred, what was the term?
Yes, I think the concept was on line 1 on page 38 of Agenda Item 4, unlawful activities shall mean violations of any formally enacted federal, state, or local law, regulation, or rule. I think that was Judge Kopp's requested amendment to that line.
All right, so why don't we
go ahead? Vote?
Yeah.
I'll move to rescind the last vote.
All right, now, all those in favor?
Aye.
All those opposed? All right, so now we have an amendment by...
Yeah, well, I'll move that language in the first line on page 38.
Second?
Second.
All right. All those in favor of the motion as amended, say aye.
Aye.
Opposed? Motion as amended passes 3-0.
Move the ordinance as amended.
Okay. We've done that. So, yeah, all right. So let's go to number 5, discussion and possible action on amendments to the Ethics Commission's enforcement and sunshine ordinance regulations.
Thank you, Chair. This is the same regulations that we brought before you in, what month is this? December, with a couple of changes that were requested by the Commission, and then, well, actually just one change was requested by the Commission, and then additional change was requested by the City Attorney's Office so that we could bifurcate a certain piece of the regulations out and go through the meet and confer process while not derailing the entire regulatory change. So the first is that the Commissioner Kopp and Commissioner Rennie expressed interest in providing 3 minutes or allowing people to reserve time for rebuttal during their presentations to the Ethics Commission on their cases. And so I incorporated that change into, let me see here, Section 10.3 on Agenda Item 5, page 20. Now you're going to go to that section and it's not going to be there. And that's because this is the wrong version. So I apologize for that error. On Section 10, the second change is to, we were advised by the City Attorney's Office that if we include the new requirement or new option for the Commission to assess administrative penalties against people who violate the Sunshine Ordinance in these regulations, that would substantially affect the rights of city employees. And so we would need to go through meet and confer on that issue. We agreed with that advice and struck that provision from this regulatory scheme so that we can go through meet and confer separately with the unions, and then we will bring back a future version of these regulations to you once that's concluded. That adds back in the ability to get civil penalties or administrative penalties. Other than that, the law remains substantially the same, if not identical, to what you saw in December.
So there'd be nothing for us to vote on in regard to what's before
Oh,
us?
I can tell you exactly what changed, and then we can just incorporate the language. Oh. What we posted is correct. Yeah. Yes. Yes, what we posted online for the notice for today is correct, is the correct version. This is just a photocopying error for the agenda materials.
And we voted on that last time, didn't we?
You did not vote last time. No.
Oh, I
You
thought
put it
we
over,
did.
put it over to this time.
Okay.
I think, if I understand on this agenda item, we have to take two votes. One is to repeal the separate regulations for sunshine ordinance. Right now, there are two separate. And then to accept the staff's recommendation of the new regulations, which incorporates the sunshine ordinance.
Makes sense.
Am I right on that?
Correct, yes.
Very good.
Repeal the sunshine ordinance regulations because they're being replaced with this combined.
Right.
Yeah.
Replacing both sets of regulations.
Right.
Okay.
So I would make a motion that we repeal the existing enforcement regulations relating to the sunshine ordinance.
Second the motion.
Okay. Do we have public comment on the motion? All right, well, then we'll vote on it. And all those in favor of the motion, please say aye.
Aye.
And opposed? None. Motion passed 3-0. And Commissioner Rennie?
And I'd make a motion that we accept and adopt the regulations as amended, as described by Ms. Bloom.
Second the motion.
All right, that motion, that's been seconded. Do we have any public comment on the motion? Yes, sir.
So you met and conferred to take the teeth out of this, and I would urge you to consider amending implementation of these regulations with a poison pill, that if, as the result of the meet and confer, you actually can create administrative penalties for city employees who disobey the Sunshine Ordinance, then these regulations will go into effect. But right now, we are protected by, what's it, AB 1455? We don't know anything. These decisions are being made in secret, in private, and the city attorney is advising you on ways to avoid the Sunshine Ordinance via meet and confer. That's what the city attorney did right to the Ethics Commission, violated the Sunshine Ordinance. So I just want to give you a little bit of background on this. Last May, I walked into the controller's office, the first Sunshine Ordinance request of my life, Public Records Act, anything. I walked in, made a request, nothing. Came back the next day, executive assistant to the controller said, you know, there are 6 people working on how to answer your request. Nothing. 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 10 days later, please speak to the school district. It's 2 sentences. Something's wrong. And without teeth, you're not going to fix anything. Thank you.
Thank you. Any further public comment? All those, well, we have the motion as seconded. All those in favor, please say aye.
Aye.
Opposed? Motion carries 3-0. Okay, we then go to item 6, discussion and possible action on proposed regulation for behested payments reporting by members of city boards and commissions pursuant to San Francisco Campaign and Government Conduct Code Section 363.600 at C.
Thanks, Chair. In January of 2017, the Board of Supervisors, via Supervisor Peskin, proposed and approved a city ordinance which would require certain board and commission members to file behested payment reports with the commission. As part of that drafted ordinance, there was provision that relayed that the Ethics Commission could, by regulation, require commissioners to electronically submit the information required in the behested payment report. It has been the policy of the commission to, where possible, to limit the amount of paper filings that we get. So we have already created an electronic system to support these filings. However, the regulation you have in front of you today just codifies that to ensure that people are required to file them in a manner we prescribe, which would be electronically. So the in agenda item 6, page 3, the short one-sentence regulation that you have in front of you there just codifies that prescription of the commission to file these behested payments reports electronically with us.
Commissioners?
So we would ask that you adopt that as proposed.
Yeah.
All right.
Well, I'll make a motion to do so.
I'll second.
Motion's been made and seconded. Is there any public comment?
Commissioners, Larry Bush for Friends of Ethics. Since this is a form that you're creating specifically for San Francisco, I'd like to recommend that you add 2 lines to the disclosures. One is a disclosure by the donor of any pending issues that they have before the city at the time that they're making a donation, or in the immediate preceding time or immediately following. And the second, a disclosure of whether any of the funds that are being donated are going to an entity that is under the control or the influence of the officer who's requested the funds. That would include whether or not the money is going to someone that they're related to, whether it's going to their own office, whatever it is. Thank you.
Mr. Chairman, can we do that with the regulation presented?
I think the answer is no. I think that'd be reading something into the ordinance which is not currently there. However, Mr. Bush's point is well taken. I just don't think it's appropriate for this action today.
Yes, okay. So that under new business, I should ask for such 2 regulations to be prepared for further action.
Yeah, well, so just as a reminder, what Mr. Bush has relayed already would be part of the AAO ordinance that was.
I know, so the old ordinance has to be amended.
Correct, but I'm just saying the AAO, that which is out there, would already do this. So this would be recommending a separate ordinance that we already have a recommended ordinance out there that would make the changes that Mr. Bush has described.
All right, that's what I want to do.
Yep. The anti-corruption and accountability ordinance that is with the Board of Supervisors now has these changes in it. So if you're saying that you want to do another ordinance that would overwrite the AAO.
Through the chair, Mr. Bush, does that satisfy you?
Yes, provided that the board passes the AAO.
Okay, thank you.
Well, we're also going to have some discussions later on about that for the ballot as well. Okay, so we have a motion before us to approve it. All those in favor say aye.
Aye.
Opposed, no. Okay, passes. We go now to item number 7, discussion and possible action on proposed regulation for financial disclosure filing proceedings. There are attachments from January 16th, 2018 staff memorandum and other attachments. Commissioners?
I'm prepared to accept the recommendation and move the adoption of the regulation.
Second.
Motion's been made and seconded that we approve the recommendation. Is there any public comment on that? Mr. Bush?
Thank you, Commissioners. One comment is that the Form 700 is filed annually, although there are changes in people's financial interest in the course of the year. And I would recommend that you adopt a policy that when there is a significant change in the financial interest of a commissioner or other person filing a report, that they amend their Form 700. The FPP says that that's certainly something that's doable, but there's no guidance that says specifically what those circumstances should be. So I would urge that in passing this, you direct the staff to provide guidance and urge that the city attorney provide an updated guide to good government that explains what the conditions are for amending a Form 700 between reporting periods. Thank you.
Could I just ask for my information, Mr. Bush, in terms of your proposal, are there particular situations, you don't have to go into any names or anything, particular situations that you've seen where there has been substantial change and people have not, and people, it would be something in the public interest?
We had a planning commissioner who was hired by Spur, and it was after December 31st. The reporting period is for January 1st to December 31st, so it didn't show up in the report that she filed in April, which she didn't file on time anyway, but you wouldn't have seen it until a following year. Meanwhile, she would have been on the Planning Commission and a Spur employee for the entire year without a public disclosure. And it's certainly true, as you know, that you also have to report your membership on a board. And as a board member, you cannot vote on issues that may impact other board members. So we have some commissioners who are on commissions, make policy that affects a broad group of people, including some who are on their own board in the private sector. So there are a number of those.
Okay. Thank you. Any further public comment on this?
Information, name changes, address.
Mr. Chairman?
Yes.
Same question procedurally. Can such a suggestion be amended to this regulation?
Not to this regulation specifically, but again, Mr. Bush's point is well taken. I think the FPPC in particular holds the Form 700 in high regard, so whether we would be preempted from taking action to amend to require the information that he's asking for is a question we need to work with the FPPC on. Otherwise, I think it would take an ordinance change to do this if we are allowed to do that. But I think we have a couple open questions whether we could do the activity in question. And it's not, definitely not for this regulation. It couldn't be amended to do what Mr. Bush has suggested.
I am thinking out loud.
Actually, I think my suggestion was that you ask the city attorney to
Pull
draft.
the mic closer, please, Mr. Bush.
I think my suggestion was intended to have you ask the city attorney to update the guide to good government. In terms of what the FPPC allows, I've talked to them, and there's no prohibition on submitting amended Form 700s during the course of the year. And I'm not suggesting any information that's not already on the Form 700, just that it be amended when the circumstances change.
And you're talking about having that in the good government guide, so that would just be advisory and a recommendation, right? There wouldn't
Yes,
be
I'm always happier if you could enact it into law and include a death penalty.
But perhaps as a step towards that, I think what we're hearing Mr. Bush talk about is the guidance that we can provide people immediately to help them understand what the current laws require. Just as a note, we are moving into the annual filing process for Form 700s, and we'll be communicating and having sessions for filers and filing officers, and we can certainly ramp up that piece of our guidance to help remind people of those requirements.
Excellent.
So thank you for that suggestion.
I'm interested, Mr. Chairman, in what would be a practical and feasible reporting period for changes of the nature described. by Mr. Bush.
Yeah, we can do some further investigation.
Yes.
Okay, so we have, in regard to the matter, is there a motion to approve it?
So move.
Second.
We have a motion to approve, and it's been seconded. Any public comment? All those in favor say aye.
Aye.
Opposed, no. Passes 3-0. We go to item number 8, discussion and possible action on monthly staff report and update of the Commission's annual policy plan.
Thank you, Chair. Sorry. So I'm just going to run through, now that that the Commission has and the public has had a chance to see our new format over a couple of sessions, I'm just going to run through a couple of updates and changes. So Agenda Item 8 on page 2, the 2017 San Francisco Anti-Corruption Accountability Ordinance. I do want to note some changes here. The Anti-Corruption Accountability Ordinance was introduced in front of the board on January 9th. I believe it was originally submitted subject to the 30-day rule to the Rules Committee. However, we have subsequently received a waiver of that 30-day rule, but because of a potential budget impact over $200,000, it has now been transferred from the Rules Committee to the Finance and Budget Committee, and it will be heard on February the 1st. Again, we are, Supervisor Cohen is the chair of that committee, and we are working with her and her staff to get them updated to make sure they have all the information regarding the process of the AAO and giving them an outline, and we will potentially work with Chair Keene to attempt to set up a meeting with that office. But that is an update regarding the AAO at this time where it currently stands with the Board of Supervisors. Moving next to the Form 700 non-voting ordinance. That was originally submitted to the Board of Supervisors with Supervisor Peskin sponsoring that legislation. There was a technical modification that was presented to Supervisor Peskin by staff, and it was that ordinance was reintroduced on October 31st, 2017. I just want to update the committee that is still pending committee action. There has been no movement on that. I would suggest maybe as a policy directive that you allow staff to reach out to sponsor and Supervisor Peskin and attempt to move this item forward, as there has been no movement on it since late October. So that is the only update there, that it is still sitting in pending committee action in the Rules Committee. The Ethics and Sunshine Training, the e-filing Form 700 project, Proposition T, and the Behest Payment Ordinance, taking those together, those were systems, forms, and training materials that were all updated for all of those items. So Proposition T and the Behested Payment Ordinance took effect on January 1st, and we just wanted to update you that we prepared and implemented electronic systems for those. So those are all up in place, and we're still finalizing a training and outreach schedule just so we ensure that there's compliance with those items. The same is true for the Ethics and Sunshine Training. So all of the sort of IT procedures and databases that are required so people can comply electronically are up to date and are being used. We are simply still at this point finalizing a schedule to ensure that we get people complying with those. I will skip over the whistleblower ordinance, as we've already had a substantial update on that item. Moving then on to agenda item 8, page 4, the planned and pending.
Before we forget, just as a point, if you could just send me an email reminder to get in touch with Supervisor Peskin.
Certainly.
The matter that.
The non-voting ordinance?
Yeah.
Certainly.
And a memo on that. That would be very helpful to me.
Okay, moving on to item 8, page 4, the legislation from Supervisors Cohen and Supervisors Kim. We are currently working with both of the staffs to update that legislation based on recommendations made by Ethics Commission staff. the city attorney's office. We are working with them to, in particular, work on the Cohen legislation that's regarding the retirement board system. So we will continue to work with those offices to update that legislation, and I'm sure both of those supervisors will be eager to present these items to you. But for now, we are just monitoring, and there's no action required. Moving to Part B, the other planned projects. You will note that items 2 and 3, the review of the Campaign Finance Reform Ordinance regulations, item 2, again on page 4, and number 3, the review of the city's public financing system. We have set dates for those projects to begin. These are large, comprehensive projects similar to what we've done with the Anti-Corruption Accountability Ordinance. Because of the sort of emerging nature of major elections in June of 2018, in June of 2018, November of 2018, and then again in November of 2019. The executive director, interested persons, and a number of others have highlighted the city's public financing system as something that people would like to see reviewed and potentially modified. So we plan to begin our formal review of that on February 1st and to begin the larger process of reviewing that program and ensuring its effectiveness is still in place. In addition to that, we are planning on definitively starting the Campaign Finance Reform Ordinance regulations review on April 1st of 2018. Those regulations, as far as we can tell, haven't been substantially reviewed since at least 2009. So we think that this is a long overdue review of those regulations, and we know that there is certainly some current areas that just aren't up to date and have practices and procedures that are just no longer concepts in law that haven't been updated based on case law, based on changes to CFRO, et cetera. So those are the sort of two large programmatic updates that we would like to begin. I think our plan is in February to present to the commission with a sort of more scoped out project plan for the public financing program, just so you can see a timeline, and we will then attempt to set interested persons meetings and when we'll bring it back to the commission for its initial review and that sort of stuff, so we can keep it better on track than we perhaps did with the AAO, just so the public is also aware. Moving lastly to page 5 on agenda item 8, the recently identified policy projects. The social media and election integrity, this has been a hot button issue. We are hoping to provide you with a more formal update in February, but for now we are reaching out to interested persons, subject matter experts, and reviewing the relevant research that is coming about the impact of social media and election meddling. We have word that Seattle, the city of Seattle actually had a social media archiving public file requirement, and they've had it in place for several decades. And recently they have told the likes of Facebook and Twitter that they will have to comply with this public filing requirement that the city has. Facebook and Twitter had 30 days to respond. They have not yet done that to tell the city of Seattle whether they will comply with that. So we are watching that closely to see how the city of Seattle and those interactions with Facebook and Twitter and other the social media sort of websites and platforms are operating. So we are keeping an eye on that closely as we move forward. Moving to the other items, the prohibition on the use of the cash out proceeds. We had the opportunity to meet with Kate Hartley, the director of MoCD, the Mayor's Office of Housing and Community Development, last Friday. It was a good conversation. We then got a chance to speak with Commissioner Kopp, and I think based on that discussion that we are tabling this item for now. They have a significant number of policies, procedures, and practices in place that make the cash out proceeds item at this time probably not something that the commission needs to take up. It seems that the city and the Mayor's Office of Housing and Community Development have that well in hand. The last item, and I believe this needs an update, but the independent city attorney memorandum or update was originally scheduled for this meeting, but I believe that has been pushed back or tabled at this time. I will look to my executive director for an update if that is incorrect.
No, we were preparing the memo. If the commission's interested in next month, we simply weren't able to calendar it with the change with the election this month.
So we'll work on that for next month. I have nothing else other than I will point in particular, Judge Kopp, we do have on page 7, it's very small here, I understand, but on attachment 2, page 7, this is the new pieces of state legislation that I have been able to identify. So obviously this looks better in an electronic format, but there are links to all of the proposals here. So these are all in very early stages, but I just wanted to let you know that there are a number of, actually most of them are reconsiderations from last period, but there are a number of ethics, campaign finance, and lobbying related bills at the state level that we are currently tracking. So I just wanted to let you know that this is updated for 2018. I don't have anything further.
Commissioners? Commissioner Kopp.
Mr. Chairman, a couple of actions I would like to seek approval. First of all, I would like to move approval of the commission proceeding with those projects set out under Roman numeral 2, subsection or section B, namely review of the Conflict of Interest Code, review of the Campaign Finance Reform Ordinance regulations, and review of the public financing systems. As recommended.
Second. The motion has been made and seconded that those matters be approved. Any public comment?
Commissioners, I have just an inquiry. In the past, the commission acted to have reports that are now filed at the Department of Election transferred to the Department of Ethics on campaign finance reports, some of which are filed there and some of which are filed here. And I didn't see that in the list of policy initiatives, and I'm not sure what the status of that is.
Are you talking specifically about the slate mailers?
Yes, I am.
Yes, it's still on. It's a still ongoing project. It's admittedly been moved back behind these other larger projects.
I would express a hope that that could happen before the June election, since there'll be a lot of slate mailers.
Okay. Any further public comment on the motion? All right. All those in favor of the motion, please say aye.
Aye.
Opposed, nay. Motion carries 3-0.
Further, I note the description of time and attention devoted to the use of so-called cash-out proceeds, and I am satisfied that Mr. Farrell's ordinance was misleading, and I was misled, because I'm satisfied that city money, city loans for low-income housing construction has safeguards sufficient to prohibit the use of any excess cash for ballot measure campaigns and similar campaign activity. That is not the case, however, with respect to Federal Housing Administration loans, but we lack jurisdiction over those. So I deem and for myself that the matter has now been concluded, and it's too bad we spent so much time and effort on it. And I want to make that announcement public because I had two visitors to my office on West Portal Avenue this past week who didn't know that it was going to be a moot subject or in that particular field. And then with respect to number 3, the independent city attorney, I thought we already had a model for that in the San Diego law, but I want specifically to request that that be on our agenda next month for action. And I'm satisfied with that San Diego ordinance. Thank you, Mr. Chairman.
Thank you, Commissioner Kopp. And we'll, and if you'll bring that up when we get to, again, when we get to new business.
Okay.
Or setting future agenda matters, that would be helpful. Mr. Plano.
I'm Bob Planthold. I wanted to refer you to page 2 to the first item, the San Francisco Anti-Corruption and Accountability Ordinance. And the reason I'm bringing this up is during the staff oral summary, I thought I heard the staff say AAO. AAO is the standard acronym for the Annual Appropriation Ordinance, the city budget. Though that term, AAO, is not in the text, I thought I heard staff say it. And I want to suggest that instead, if you're going to use an acronym, it'd be ACAO, but not AAO. You will confuse people who hear that. That's all. Thank you.
Thank you. Any further public comment?
Well taken.
I don't think we have any action to take on this. If not, we'll go to item.
Chair, we have a
I'm
request
sorry.
for a quick 10-minute break.
Oh, sure,
Thank you.
certainly, yeah. But we'll be in recess for 10 minutes.
Yep.
SF Gov TV, San Francisco Government Television.
We're back in session, and we'll now go to item 9, which is discussion of the enforcement report and an update on various programmatic and operational highlights of the enforcement program's activities since the last monthly meeting.
Thank you, Chair. We had a productive month. We received 9 new complaints. We opened 11 new investigations, and we dismissed 23 complaints, which put a significant dent in our outstanding preliminary review matters. The details for which I can't, oh, no, I have it in here. 58 complaints only remain in preliminary review. So when we started this process, when we were down all investigators, we had almost 190 unreviewed complaints, and we're down to 58. So I'm proud of my staff. They're doing a great job. And thanks to everyone in the review chain who has to get through all of that information. It's a heavy lift. I also wanted to highlight that regarding, you'll recall that the Sunshine Ordinance Task Force received a complaint that this commission violated the Sunshine Ordinance regarding taking a vote taking a vote on something that wasn't on the agenda, and the task force decided that you did not violate the law. The Sunshine Ordinance Task Force has decided to reopen that complaint, even though it was finally adjudicated in December with the issuance of their final order. And we have declined to participate in that process. So I sent them a letter explaining that we felt we had fully complied with our obligations and provided all the facts and argument that were available to us regarding the incident previously in the first hearing. And I also asked them for a citation to authority that allows them to reopen a finally adjudicated matter. And I have not heard back. And when I do, I will report back. The additional details and statistics regarding the complaints start on page 2. We now have 63 open investigations, just 11 additional ones over the last month, and that caseload is growing as we get through the remaining 58 complaints. We'll have more and more investigations, but we're also working towards stipulated resolutions in several of them, and you'll have some findings of no probable cause and findings of probable cause coming before you over the next couple of months as well. And then you can see the matters that are with the Bureau of Delinquent Revenue are coming along, and people are still keeping up with their payment plans. So with that, I'll answer any questions.
Commissioners? No. Any public comment on this item? Plantel?
I'm Bob Planthold. As a veteran of 7.5 years of the Sunshine Task Force, I want to bring to bear on the report about the Sunshine Ordinance Task Force hearings on the complaint. Some weeks after the hearing where the decision was you didn't violate, I contacted the administrator for that body to say what's the basis and what's the timeline for any appeal or reconsideration. You folks haven't mentioned that in here. There was a timeline, a relatively short timeline, after the decision is made for reconsideration. I believe that timeline is long past. So even if there was grounds for somehow taking the DA's decision into account, they missed the deadline. And that hasn't been stated in here. Maybe it's been stated in the letter. It just bothered me that suddenly the task force seems to be saying, well, somebody else differed with us, so we'll go along with them. And that's why the procedural issue of the timeline, it can be as important. And I'm mystified. Did the task force say why and how they think that somebody else's decision made after theirs is new facts as opposed to a different analysis? Because my understanding is they can only consider new facts, new information, not new analysis. And here again, I'm bringing those questions because who knows who's going to go to what media and paint some picture their way unless you're able to quickly say it's not new facts and they missed the deadline. Thank you.
Thank you, Mr. Plantel. I have to just say that my one experience with the task force was very underwhelming, and they continue to further underwhelm me by what they do. Yes, sir.
My name's Douglas Yep. I would like to thank the Ethics Commission and its staff. In my limited analysis, I think they're doing a very good job, especially compared to the old regime. I'm making a prediction that this is going to turn out to be another Me Too movement. When the public is convinced that there is enough momentum, that their complaints will be seriously considered and correctly handled. There's plenty of people sitting right now watching the TV, waiting to be convinced, and then all of a sudden, those complaints will come 1, 2, 3, because most of them know who the obstructionists are. Some of them will be exposed, and ultimately, the Ethics Commission up in the sky is going to be issuing more penalties, and maybe if we're really lucky, there'll be some death sentences handing out to some deserving people.
As an opponent of capital punishment, I don't like you to keep saying that. Any further public comment? All right. We'll move then to agenda item 10, discussion of the executive director's report.
Thank you, Chair Keen. My report provides some information on some significant operational developments. I won't go into a lot of the details, but Kyle Kundert's policy report also mentioned that with the new year, we have new tools available to help people comply with some of the new requirements that took effect January 1. So we have new Behested payment reporting information online, new tools for lobbyists to register online to comply with Prop T that was passed last year. 2016, November of 2016, and some other refinements for the lobbying program. I do want to note that we are getting a lot of good feedback through our engagement and compliance team from filers who are working through the system. As we identify any hiccups or bugs, we are working with our IT staff quickly to try and resolve those things. So we do appreciate both the candid feedback we're getting from filers as well as people's patience as we unroll these things. We really are excited about the ease of the filing requirement tools that we're providing. So that's something that I think Stephen Massey and his team and others in the office put a lot of time and effort in, and obviously those folks who have to file with these mechanisms are also going to be giving us great feedback, so we appreciate that. As you know, with the election called for the mayoral race for June 2018, we've also done a significant and unplanned ramping up of our activities to try and provide compliance, guidance, and assistance. We did have a first session for candidates focused on the 2018 June mayoral race, an information session that we had about 20 attendees, and we're updating information and supplemental guides to help with that process. We will continue that, of course, as we move more heavily now into the public financing, eligibility, and claims phase of the election, and we have started that with our staff as well. And we'll report on that as we go forward to keep you informed about the level of activity in the campaign around public financing. I do have a significant note that is unusual and not a frequent occurrence for us, but as I also report in my report, this week, actually last week on January 11th, papers were filed in Superior Court by one of the mayoral candidates, Angela Alioto for mayor, and Angela Alioto for mayor 2018 committee, seeking an order to enjoin certification for public financing by the Mark Leno for mayor 2018 committee. Those papers were filed. An initial hearing was held last Friday in Superior Court, Department 302. We were represented as a named party by the city attorney's office, Andrew Shen in particular. And this morning, after a subsequent hearing and subsequent papers filed this week, the judge issued a tentative order denying injunctive relief, and I'll leave the details for the city attorney to provide you with, but I just want to convey our appreciation and thanks to Andrew Shen in particular for really getting some terrific papers in and being very solicitous of information from our office to make it an effective presentation. I'm happy to turn it to Andrew for any other detail, or if the commission has any questions.
I'll be just very brief. First thing, I just do want to clarify for the benefit of the commission and the audience, even though the document is titled a tentative order, Judge Ulmer did adopt it as the final order from the bench at this morning's hearing. And I also want to thank, on behalf of my office, I want to thank the staff of the Ethics Commission for being so readily available. As you can imagine, in a TRO context, you do need to collect information very quickly, provide information very quickly to the court. And so they were always very helpful and responsive and quick to answer my questions. So thanks to them.
Question.
Yeah.
Commissioner Cobb.
What was the legal issue?
The sole cause of action or the sole claim in the petitioner's complaint was that the Mark Lono campaign, I suppose in conjunction with the Ethics Commission, was violating the Campaign Finance Reform Ordinance by not following one of their regulations that define what constitutes a matching contribution for the purpose of the public financing program.
Okay.
So again, congratulations again, Andrew, and thank you for that. We had hoped to have an initial presentation about the budget today for this agenda. The budgets will be due to the mayor's office February 21st, I believe, and that does follow our next commission meeting. So we will have a full package of information for you before our budget is submitted to that office. Again, we're keeping a very close eye on what any cuts as the budget instructions have requested of all departments. But we will come forward with items that we know that we need to continue the work that has been started through legislation as well as operational changes at the Commission over the last several years. And then finally, I do want to introduce to you Tyler Field, who is our newest new guy. A mantle no longer worn by Pat Ford on the policy staff. But Tyler is here, if you can just stand up and say hello. Tyler joined our office this week as our new information systems business analyst. He's working with Jared Flores and Stephen Massey to continue to develop our technology solutions for filing, operational needs, and access to electronically filed disclosure information through visualizations and analysis to really get this information that folks file with our office into the hands of the public and make it very meaningful. So Tyler is terrific. He was formerly an informatics engineer, and he has a BS degree in aerospace engineering. So I think we've got a good team that we're putting together here. He's also got terrific experience doing coding related to interactive visualizations on election-related information and other campaign-related data. So it's a terrific fit. We're really delighted he's joining us, and I wanted to formally welcome him and introduce him to you today.
Very impressive. Good to have you, Tyler.
Lastly, we are continuing to work with the Department of Human Resources on our remaining hires. We have 2 positions that have been through, actually 3 that have completed or virtually completed the oral interview phase. So we have 3 other positions that are going to be posted, but we are continuing to work with the Department of Human Resources closely to make sure that we can be as aggressive as possible to get the remaining seats filled in the next number of months. So with that, I'm happy to answer any questions if you have them for me.
One comment I would have in regard to your discussions with the mayor's office having to do with the budget, since we now have a new mayor, I think it would be good to remind the mayors and the mayor's budget people of what we emphasized very much with Mayor Lee, I think very effectively, that in regard to our budget, that we have the power and we would think very strongly of doing it, of putting on the ballot, taking away the mayor's authority to set our budget if they were to cut us in regard to our needs, because all of those years when Mr. St. Croix was here and never asked for anything, and everything went down, and we're finally now getting up to speed, and we're seeing people like Tyler and the rest of you. It's working right well. We would not welcome any kind of cuts, and nor would any kind of cuts be in any way deserved, given the history of the commission and the fact that we're finally in a position to get the commission running as it should. So I hope that in either as diplomatic or undiplomatic a fashion as you can bring that to the attention of the mayor's budget people as you negotiate for the budget that we want to keep. Commissioners?
Well, Mr. Pelham, I would appreciate it if you would sort of enlighten the other commissioners and the public about the efforts to set up a telephone system and where that stands.
Thank you for asking that question, my oversight. We have a meeting set for January 24th next week with the administrative and technology people here from this building. It is the case that there is apparently only one meeting room that allows for a telephonic input by people remotely, and that is a meeting that happens at the same time this one does. So there is not currently technology that we can use in this room to simply sort of patch in public comment by phone. We are meeting, we've started understanding the issues. We're meeting with the technology folks to identify what would it take to enable that to happen, whether it's through a new technology that they need, that they can plug and play, or whether there's something we can do through the VoIP computer technology to get folks in on conference calls or something of that sort. So we're going to identify what it is that it would take to accomplish the goals that that you've mentioned and the commission mentioned in establishing the meeting days as we have, and that our plan will be based on that to fully make a request through our budget as necessary to try and make that happen.
Thank you. Any public comment?
Hi, Charlie Marsteller for the record. I'm wondering if we could maybe switch rooms with the other people. Nope. And I also noted you have 2 auditor positions coming up since oral interviews have been completed. And I imagine they might be hired in the first half of this next calendar year, which is probably because we are obviously going to have some draw on the public financing. So for the emphasis of concurrent and proactive audit and enforcement, I think it would be good to go a full blast as we can on the auditors, so we don't lose those resources within house. And it would be a good training opportunity, I think, as well. And I'm wondering if there's any monies that are given to the department or involved with the special election process. Is there any discussion about the Department of Elections and the Department of Ethics receiving additional funds?
I would like to say I wish, but not that I'm aware of, no. Now, one clarification is there is a provision in the law for a public financing program that does require, when there is a vacancy in the office of mayor called, an election called, that there is a requirement that an additional $8 per resident be accounted for in our election campaign fund. And so we communicated and confirmed with the controller's office that that level of funding does exist in the current funds balance. So, for example, if all mayoral candidates, the 6 who have qualified to be on the ballot and indicated they want to be public financing participants, if each of them were to become eligible and receive the full amount of public financing of $975,000 for their campaigns, the fund would have sufficient funds to withstand that draw. But that will also be another question then come November's election. There may need to be additional funds put in based on the language that exists in the charter. But as to our administrative costs, given that there is an election called, there is not a provision that does that for us particularly.
I would imagine DOE gets special consideration because they may have to set up polling stations and pay workers. And also, how many candidates have filed for public financing so far? Do you know?
Well, there are, in terms of what we mean by filing, there were 8 candidates in the mayoral race that were qualified for the ballot. 6 of those 8 filed statements of interest to participate in the public financing program. And I believe out of the Board of Supervisors race for June of 2018, there were 3 candidates that qualified and 2, I believe, expressed an interest in participating. I may be off on the budget or the Board of Supervisors race, but 6 of the 8 in the mayor's race have filed to participate. As we came to the meeting today, there have been no requests by any mayoral candidate to actually be certified or to receive public funds yet.
Oh, so certification is still yet to come for those 6. So that number may not be the full 6. They're keeping their options open at this stage.
No, to be clear, the candidates, when they filed their nominating papers to be on the ballot, were required to also at that time submit a statement whether they intended to participate in the program. So 6 of the 8 candidates filed statements each of them happened to indicate they wanted to participate in the program, the next step then would be the candidates requesting certification to be eligible to receive public funds from our office. And then the next step after that would be to actually submit a matching funds claim once they have been certified as eligible for public financing. The certification of eligibility is relevant and important because it releases a first initial grant to candidates for their campaigns. After that point, they will then submit matching funds claims to have contributions matched up to the limits within the law. So I hope that clarifies the filing process a bit.
Yeah, so I'm doing this in part for the public who's watching. But I'm also wondering, too, if by the next meeting of the commission, which is on the 16th, I believe, then we'll have a clearer picture as to who's been certified. Yes. And at that point, they'll be raising funds, and we'll have more data. Great. And you'll also have a clearer picture on your staff demands. Yes. Especially if they're all going for big money. Mayor's office requires considerable funds because you're reaching out to everybody in the city in a very robust and aggressive way, especially when there's a strong candidate base. Thank you.
Thank you. Any further public comment? All right, we'll go on then to agenda item number 11, discussion and possible action regarding status of complaints received or initiated by the Ethics Commission, and there's a possibility of a closed session.
I request a closed session.
All right. There's been a request for a closed session. Is there a second?
I'll second it.
All right. All those in favor of the closed session?
Aye.
Aye. Opposed? Okay, we'll go into closed session. Yes, Andrew.
Sorry to interrupt, but before we go to closed session, we should provide an opportunity for public comment.
You're right. Okay, any public comment on our going into closed session?
How long do you think you'll be?
15 minutes.
Oh, quick. So you'll come back into session, and there's really not much on the agenda, probably. So
We'll sneak in a bunch of.
we probably are going to leave you.
There'll be some new business.
But we'll wish you a Happy New Year. And I also did want to say that in this agenda, I've seen evidence that you guys are putting some teeth in your toothless tiger. So I appreciate your hard work.
Thank you.
Thank you.
Okay, well, we'll be in closed session then if there are no, unless, Mr. Plano, did you, okay. All right, we're in closed session then.
There's no denying it's unhealthy. It makes you cough and hurts your lungs. Burning wood in your fireplace pollutes the air outside and inside your home. Safeguard your family's health this winter. If your home is smoking, it's time to quit. It's your air. Protect it. To learn more, visit sparetheair.org.
I'm passionate. I'm dedicated. I am an alligator.
This is a tree that was never chopped down to make a crutch that was never needed by a child who never got polio because a vaccine was never in short supply. Thanks to people whose compassion wasn't either. You can help Rotary end polio now. Learn how you can help at rotary.org/endpolio. Rotary. Humanity in motion.
My family story starts in Jalisco, Mexico, in a little small town called Mezcala. My parents are from a very, very small town. I mean, so small that my dad's brother is married to one of my mom's sisters. You know, that's how small it is. A lot of folks from that town are here in the city. Like most immigrant families, my parents, you know, wanted a better life for us. So my dad came out here first. I think I was almost 2 years old when he sent for us, and my mom and myself came out here. We moved to San Francisco early on in the Mission District, and then moved out to Daly City for a while, then bounced back to San Francisco. We lived across the street from the UPS building. So for me, my earliest memories were the big brown trucks driving up and down the street, keeping us awake at night. I'm 6, 7 years old, and I'm in charge of making sure that we all get on the bus on time to get to school. You know, I got to make sure that, you know, that we do our homework. It's a lot of responsibility for a kid. The weekends were always for family, so we used to get together, and whether we used to go watch a movie at the New Mission Theater, and then afterwards going to Kentucky Fried Chicken on Valencia. That was big for us, you know. We get Kentucky Fried Chicken on Sunday. Oh, woo, going crazy. So for me, home is having something where you're all together, whether it's just together for dinner or whether it's together for breakfast, or sharing, you know, those special moments, the holidays, you know, whether it's Thanksgiving or Christmas or birthdays. That's a home to me. Being so close to Berkeley and Oakland and you know, Vallejo, San Francisco, Daly City, there's a line, and here you don't see a line. And even though you see somebody that's a little different than you, they're still equal to you, and you've always seen that. A rainbow of colors, a rainbow of personalities. When you think about the DACA, you're supposed to be protecting the kids. They have dreams, they have aspirations, they have goals, and you're taking that away from them. Right now, the fight that they're fighting is a hard fight, but I mean, they're determined. I mean, these kids, you gotta applaud them. You know, their heart is in the right place. There's hope. I mean, you know, out here with things changing every day, we just hope that the next administration makes the change that makes things right. You know, right now, there's been a lot of changes on a lot of different levels. So, you know, the only thing you can hope for is, you know, for the future and these young kids and these young folks that are getting into politics to make the right moves and make the right decisions for the folks that can't speak.
With Chewy Gomez and DJ Mind Motion, driving you home.
Even though we have a lot of fighters, there's a lot of voiceless folks, and they're voiceless because they're scared.
Bring it down.
About 2 years ago now, I had my first child. And I thought, when I come back, you know, I'm going to get back into the swing of things, and I'll just pump in the office somewhere. I'll find a spot. And it wasn't really that way when I got back to work. And so that's what really kind of spurred me to think about the challenges that new mothers face when they come back to work.
When it comes to innovative ideas and policies, San Francisco is known to pave the way. Whether it's fighting for social justice or advocating for the environment, our city has served as the example and as the leader many times over. And this year, it leads the nation once again, but for a new reason, becoming the most supportive city of nursing mothers in the workplace.
I was inspired to work on legislation to really help new moms return to work because one of my legislative aides actually had a baby while she was working in our office. And when she returned, we had luckily just converted a bathroom at City Hall into a lactation room. She was pumping maybe a couple times a day. And had it not been for the fact that this lactation accommodation was just right around the hallway, I don't know that she would have been able to continue to provide breast milk for her baby.
While Ashley was fortunate to have a space to pump breast milk at work, not all returning mothers have that same access, even though there's existing state laws on the issue.
These moms usually work in low-paying jobs, and they're returning to work much more sooner, and they don't feel well supported at work.
We started out by having legislation to mandate that all city offices and departments have accommodations for mothers who want to return to work and lactate. But then this year, we passed legislation to require that all private sector companies have lactation accommodations and policies for new moms who are returning to work.
And with the new accommodations, moms should have a smoother transition once they return back to work. So what are some of the accommodations that this legislation highlights?
We wanted to make it applicable to all businesses and all employers, all nonprofits, and the way we did that was we created a set of minimum standards that could be easily achievable by anybody.
You mentioned our own City Hall has a lactation room. Do you have a few minutes today to give us a quick tour?
I would love to do that. Let's go.
Awesome.
Yeah.
All right. This is such an inviting space. So what makes this a lactation room?
Well, as our legislation requires, it does have the bare minimum standards. So we have a seat. We have a surface to place your breast pump. We also have a clean space that doesn't have, you know, any toxic chemicals or storage or anything like that. The other thing that makes it really important is that we have electricity. So we have plenty of outlets for pumps, for a fridge. The things that make it a little bit extra is that the fridge is actually in the room and the sink is actually in the rooms. Our legislation does require a fridge and a sink nearby, but this room is great because it's all right in here. So you can wash your pump, you can put your milk away, you don't have to put it in any sort of refrigerator that you share with your coworkers.
The new standards will be applied to all businesses and all places of employment in San Francisco, but are they achievable for the smaller employers in the city?
I think that small businesses rightfully have some concerns about providing lactation accommodations for employees. However, we did leave a lot of leeway in the legislation as well to account for small businesses that also may have small footprints. And so, for example, we don't mandate that you have a lactation room, but rather a lactation space. So in City Hall, we actually do have a lactation pod here that is open to the public.
So the more that we can change, especially in our governmental offices, the more we can support women.
I think for the workplace to really offer support and encouragement for pumping and breastfeeding mothers is necessary.
What's actually most important about the legislation is that, number one, we require that an employer actually have a lactation policy in place and then have a conversation with a new hire as well as an employee who requests parental leave. Because otherwise, a lot of times, moms don't feel comfortable asking their boss for lactation accommodations.
Really, it's hard to go back to the office after you've become a mom because you're leaving your heart outside of your body. And when you can then provide your child food from your body and know that you're connecting with them in that way, I think it means a lot to a mom emotionally and physically when they go back to the office to be able to do that. But also businesses and employers can just provide a space. If they don't have a room, they can just provide a small space that's private and free from intrusion to help a mom pump. And I think that's going to attract moms to working for businesses in San Francisco.
If you'd like more information about the Workplace Lactation Accommodation Program, visit sfdph.org/breastfeeding at work.
Hi, everybody. This is exciting. My name is London Breed. I'm the acting mayor for the City and County of San Francisco. Really excited to be here. And as many of you know, I grew up in the Western Addition, Fillmore neighborhood, but my mother lived in Potrero Hill, so I spend a lot of time on Connecticut and 25th and actually in this gym hanging out when I was a teen. And so there is definitely, this place is near and dear to my heart. I want to thank the staff of the Potrero Hill Recreation Center for your work here in the community. Thank you all so much. And thank you to our director of our Rec and Park Department, Phil Ginsberg, who's here with us today. And his team and the people who continue to work to keep our parks beautiful all over the city. I also want to thank our chief, Bill Scott, and members of the San Francisco Police Department, the folks who are actually working with Peace Parks, which is an amazing program that we're going to be talking about today. Thank you, Chief Scott, as well as your fearless leader, the supervisor for District 10, Supervisor Malia Cohen, who will be speaking shortly. And so today we're celebrating the launch of Peace Parks and the vision of bringing our communities together for healthy, positive activities and to reduce gun violence in our city. And I want to thank also Supervisor Cohen because the ballot initiative that she put on the ballot, the soda tax, the funding from the soda tax also is used to pay for this amazing initiative. So getting the money to pay for this great program, all due to your supervisor. So, you know, growing up in the Western Addition, it was really sad that violence and gun violence in particular was a common occurrence. You know, sitting at home, trying to do your homework, and you hear the gunshots, and you're just praying that the person, that no one was shot, but, you know, you're thinking about your family, you're thinking about your loved ones, and that sadly was just really normal in my community, and that shouldn't be normal. You know, we've lost so many people over the years, and I know that Sean Richard, who's here, who started Brothers Against Guns, started this organization as a tribute to his brother, who he lost. He actually lost two brothers, but particularly Tracy, who I went to school with, and I love Tracy. I love Tracy. He was one of my brother's best friends, and I think about, you know, Tracy, who should be here with us today, and I think about so many people that we lost, and I miss them. I miss my community. I miss my friends. I miss my family members. And when we lose someone to gun violence, we can't bring them back. We can't bring them back. So we have to have an alternative. We have to have something that makes a difference in our communities. We have got to make sure that when our young people grow up in these communities, that they have incredible opportunities like other folks in other parts of our city. You know, I was really, really fortunate. I went to college. I was in the Mayor's Youth Employment and Training Program. I didn't even know why I was doing these things. There were these incredible people, these mentors, and they were like, we want you to do this. We want you to do that. I'm just like, okay. But I didn't understand how important it was and how it was going to change my life. And I want that to happen for every young person in San Francisco. I don't want selling drugs and using guns and doing all this other stuff that's destroying our community to ever be an option. The alternative has to be the norm. And so this is something that I am so committed to, and I have worked hard, specifically in the Western Addition, to not only provide opportunity as the executive director of the African American Art and Culture Complex, but also bridge the gap between the police department and the community. So when I was growing up, oftentimes when the police came to the community,
I think we're back. Should be able to gavel back.
Okay, we're back in open session. Is there a motion to not reveal what was discussed in closed session?
So move.
All those in favor of the motion, say aye.
Aye.
Opposed, no. The motion carries 3-0. Okay, we'll move now. Do we need any public comment before we go? Okay, any public comment? We'll go to item 12, discussion and possible actions on items for future meetings.
Mr. Chairman,
Cobb.
I have two items. One is I should like to schedule for our March meeting a item to submit to voters at the next possible election, a charter amendment to provide for independent counsel for the Ethics Commission. And as noted in a prior discussion touching that subject matter, the San Diego law is a model which, in my opinion, would be satisfactory. Secondly, I would like legal research and, as appropriate, preparation of an ordinance dealing with a practice that has been commented on, I guess, previously and certainly prior to my appointment to this commission, of candidates for office in the city and county of San Francisco using funds from a campaign committee for a party county central committee. In this instance, the Democratic County Central Committee is the one which has come to my attention, in which a donor can exceed the $500 per person contribution limit of our campaign and anti-corruption law. And for example, there are contributions to a couple candidates for mayor, such as $1,000 from Emerald Fund, a real estate development corporation, $20,000 from Salesforce, $5,000 from the Laborers Union, $4,200 from the CEO of a corporation called AGI Co., $5,000 from Boston Properties, another commercial real estate developer and operator, Green Cross, $1,000, a marijuana dispensary corporation, and in-kind contributions amounting to a value of $12,000 for parties and for example, one of the candidates used $7,000 on a parade float from a campaign for Democratic County Committee account. It's all for purposes of name recognition. That's obvious. And it's a form of what used to be called a slush fund. I'm not sure of the legal prerogatives of the city and county of San Francisco because county committees are authorized under the Elections Code of the state of California. But if at all possible legally, I would ask also for calendaring at the March meeting a preparation of an ordinance to prohibit the use of money contributed to a campaign to elect a candidate to a county central committee, a partisan county central committee, whether it's the Republican Party, the Green Party, or any other party, for campaigning for public office, elected public office in San Francisco. Thank you.
Thank you, Commissioner Kopp. Commissioner Rennie? Okay, so I think that on both of those, if the staff can work with Commissioner Kopp on proposed language for us to discuss at the March meeting, that would then be helpful. So we can use that for our discussion. At our next meeting, as we had earlier talked about, we're going to be taking up the whistleblower matter to put it on the ballot. And in addition to that, also be taken up, I would expect, the corrupt practices ordinance in order to have both of those on the June ballot. So those are a couple of things that we should gear up for in order to vote on next time, because we'll need the supermajority in order to put those on the ballot. Those are the only things that I have. Nothing further. Okay, any public comment? Is there any additional public on item 13? Is there any additional public comment on any matter appearing or not appearing on the agenda? Yes, sir, Mr. Yep.
Good afternoon. My name's Douglas Yep. The first thing I'd like to say is that I'm fully supportive of hiring more staff. Basically, all those past years, we all know what happened. So we have to gear up, and we have to tell the public that it's like a football team. This is not the JV squad anymore. It's going to be a real team. And when one person leaves for whatever reason, there'll be adequate backups. So in other words, the success will continue in an orderly fashion. Secondly, is that the example of Harvey Weinstein, when he started it, it just got bigger and bigger and bigger. I guarantee you there's plenty of viewers listening to what I'm saying. They're secretly saying, when those guys are staffed, I'm going to file my complaint. And then people in the past, like Oliver Luby and Joe Lynn, will say, we've waited and waited, and now the tide is turning. It's like water. Slowly it goes up, and then it floats the junk to the top. It's basically, that's what people are waiting for. They want a real football team. It's not playing with the JV like the previous director. It's obvious you mean business, and people will come and complain and give you the proof, just like the U.S. gymnasts for the women's squad. One doctor was able to shut them up until a couple of women got brave, then another step forward, another step forward, another step forward, and now we see what's happening. So the same thing's going to happen in San Francisco. People are not going to say, well, Chicago is corrupt, New Orleans is corrupt. They're going to start saying San Francisco is corrupt because we're going to make a difference. And let's put it this way. There's plenty of people that did all the legwork in the previous years, and they will be cheering you on. And let's put it this way. I think the commission is ready to handle something so sensitive, nobody, not even a certain ex-mayor, wants to even mention the name. The name is Joseph Mollespin, M-A-L-E-S-P-I-N, ex-gay city employee, the last person I worked with. He had plenty to say, and he paid the ultimate price for what he had to say at the hospital. I think the time is coming soon that the city will look into Mr. Mollespin and will find out the real truth of what happens to a dead gay man in San Francisco.
Thank you. Any further public comment?
Move we adjourn.
Second?
Second.
All those in favor say aye.
Aye.
Aye. We are adjourned.